I miss Attorney General Alberto Gonzales. At least, each time he defied the Constitution and the Congress, he always said the same thing. In our third story tonight, Michael Mukasey has today given his fourth distinct answer about waterboarding. In a letter to the Judiciary Committee yesterday, Mr. Mukasey mutated from saying he knew at some point he'd have to say whether waterboarding is always torture, i.e. illegal, to no, he had no intention of choosing. Much of today's expected outrage over that, however, missing the astonishing fact that Mukasey, after now reviewing secret DOJ legal rationales defending waterboarding, also refuses to outright endorse Mr. Bush's prior use of waterboarding. Perhaps more astonishing still, in the course of the waterboarding debate, Mukasey, the nation's top lawman, allowed that Mr. Bush may have broken federal law on at least 2 more occasions.
Torture, as you know, is now unlawful under American law. I can't contemplate any situation in which this president would assert Article 2 authority to do something that the law forbids.
Well, he did just that in violating the Foreign Intelligence Surveillance Act. He did just that in disregarding the express mandate of the National Security Act to notify the intelligence committees. Didn't he?
I think we are now in a situation where both of those issues have been brought within statutes, and that's the procedure going forward.
That's not the point. The point is that he acted in violation of statutes, didn't he?
I don't know.
And while refusing, astonishingly, to rule out future waterboarding, Mukasey did define some depths to which even Mr. Bush would not stoop.
Would waterboarding be torture if it was done to you?
I would feel that it was.
Are there any interrogation techniques that you would find to be illegal, fundamentally illegal?
There are statutes that describe specifically what we may not do. We may not maim. We may not rape.
At this point, let's turn to John Dean, author of Broken Government, How Republican Rule Destroyed the Legislative, Executive, and Judicial Branches, and, of course, the White House counsel to Richard Nixon. John, great thanks again for your time tonight.
Thank you, Keith.
Would your old boss, Mr. Nixon, have kept his job a little longer if he had offered to Congress and the people the defense, I am not a crook, but I am not a rapist?
Well, he tried the I'm not a crook, and that didn't seem to work. But, you know, Keith, in his darkest moment, I can't imagine Nixon tolerating torture. I can really say that in his defense. We are on such a different playing field with this presidency.
How solid is the playing field on which Mr. Mukasey stands when he says his position precludes him from venturing an opinion? Should we not be expecting him more than others to say America does not have a set of secret laws somewhere and we are going to prosecute those who break the laws, especially if they do so under official cover?
One would hope so. The question of how solid is the base, there is absolutely no base for what he's saying. It is a conspicuous ruse to the committee. The committee recognized it today. I watched a good bit of those hearings. They were not buying his claims. They were not buying his stonewalling. And they were very disappointed in him. Those even who sponsored and helped him get his seat are now showing some remorse, at least in the way he's handling this issue so important to the country, torture.
And if he doesn't know, if he actually has to answer, I don't know, whether the President of the U.S. violated 2 federal laws, is that not one of those automatic bells go off kind of things in an Attorney General's mind? That's the kind of thing you're supposed to look into. Maybe you have a staffer write you a memo about. Is that not an automatic?
Well, I've got to tell you, there's a long tradition of attorneys general not investigating their bosses. This is not a new trend. What an attorney general should be doing, and what most of them have done in the past, is try to make sure their bosses are not breaking the law, to give them advice and counsel to keep them away. And I think that's the sort of opinion I'm surprised he didn't offer the committee today, to say something to the effect, listen, I've told him that this is out of bounds and this is something you can't do.
To some degree, I mean, I think in fairness to him, to some degree he did say that regarding things that have now been brought under statute, referring obviously to some of the FISA stuff spectacularly in that instance. But that insistence, you look forward, you have a blind eye towards possible past misdemeanors by the man for whom you work? Does that tell us that he views his job principally as protection of the president rather than protection of the Constitution?
Well, I think that's what we have. He's certainly over there as a caretaker attorney general. It's not a long term he's in for, and he's there to be something of a firewall for the president. He's playing the role of judge as to what he thinks is across the boundary line and not across the boundary line. We can only hope, Keith, that his advice in private is stronger than his advice he's willing to share.
So lastly, John, we've had, as I said, 4 separate statements from him, essentially, about waterboarding as torture. Tell me what sort of attorney general goes from, before his hearings, his confirmation hearings, that he wasn't sure, he couldn't define, he hadn't been read in on it. Then he said, I guess about a month ago, he knew the time was coming there where he's going to have to make some sort of statement. And then last week he said, you know what, I'm not going to make any kind of determination on this one way or the other. I'm not going to say it officially. And now this latest answer is, if it was done to him, yeah, he'd feel like it was. What kind of attorney general can give you 4 answers to the same legal question?
Well, I think what he's obviously trying to do is avoid the question. As soon as he answers the question, and the answer is so conspicuous to everybody, almost non-lawyers can figure this out, that under the broad terms of that statute, it could well include waterboarding, and probably does include waterboarding. So once he crosses that threshold, he's got to be asking, well, can I be looking at the president and the vice president and others for war crimes? And that's where he doesn't want to go.
All right, well, I'm going to close where I began. I miss Alberto Gonzales, and I miss Richard Nixon now, too. John Dean, author of Broken Government and the voice of our Broken Government segments. Great thanks as always, John.
Good night, Keith.